Friday night and he's pulling them over left and right. He sort of looks like Darth Vader with his gun and his radar and his flashing blue light. He drives a government squad car full of all kinds of hardware to handle the angry mob. And with his badge on his shoulder and his gun in his holster, he'll tell you he's just doing his job. Watch out for martial law, martial law. He's there to prove who owns the muscle. Pull you over to the side of the shoulder, cause he cannot see your license plate light. Because he cannot see your license.
Constitution, I'm going to show you how it applies. Any questions?
Now that we've gone over the Constitution and we've talked about some of the ways that you can use it, now we're going to go into some of the ways that you can apply it, okay? We would like to ask a few questions of the audience, though, first. If anybody has any questions that so far maybe they don't understand or they have an idea. Yes, you, sir.
Yeah, how do I react properly if a police...
Okay, we're going to cover that. We're going to cover exactly what to do in the event you're pulled over, and we're going to cover how to handle most of your traffic cases, okay? But basically the most important thing to do is to be very courteous at all times. Extend to every person the courtesy that you would like yourself, okay? And my honest advice is if it's yes sir, no sir, you treat the officer with some due respect. And most of the time you'll find that if you treat them professionally, they will respond in kind. And usually they'll treat you professionally. But the bottom line is if you react with a negative attitude, you're going to get negative attitude back, and that's non-productive. So I highly recommend you accord the officer every respect. Remember, he is out there risking his life every day to protect the public, and you know, you have to understand most of the police officers are professional, and they will respond professionally. Every now and then you're going to get a yahoo, but that's the way it is in life. I mean, but most of the people, if you treat them respectfully, they will respond in kind. Yes, sir, you back there.
Yes, I was wondering about the concealed weapons carrying procedures. Do I have a right to, or should I leave it home? What should I do?
Well, you do have a right, and we will go over that very thoroughly. We're going to go into the second part of this program right now. We're going to teach you, one, how to be your own counsel in court. We're going to teach you some of the arguments that you can use with the training that we've already given you. And we're going to show you how to graphically use your constitutional rights to exercise your rights. So that'll be covered.
Right.
You, sir.
Yes, if I'm pulled over just while driving down the road, can you give us some idea of a procedure that, what procedure to say, what things to say, what not to say, and that sort of thing?
Well, the things to do, first of all, is when you pull over, try not to demonstrate any rapid movements or any like you're reaching under the seat or you're reaching in the glove box. Keep your hands where you can be seen. Do not overreact. Try and be calm. Talk to the officer in a mellow voice. Don't yell or holler or use profanity whatsoever. Basically, it's yes, sir. You know, what can I do for you, sir? They'll usually ask you to produce your documentation. You have license, proof of insurance, and the registration of the vehicle. Okay, now we're going to go into a lot of issues on those. Programming to cover that, to show you some of the things that you can do and what you can opt to do. Also, I recommend that you treat the officer, as I told the other gentleman there, very courteously, because that is going to get you a lot farther ahead than giving them a lot of negative hype or trying to outshout them or give them a lot of static. So my honest counsel is, let me show you how we proceed. Most of the time, you will be able to leave the scene without any serious injury. You might have a ticket or this or that, but we'll show you how to deal with that, okay? But you need to be understanding that this party is an armed party, and you don't want to do any movements that's going to cause him to overreact to an injury of you. Yeah. And you'll find that a lot of times, this is the most dangerous thing a police officer does, is stop people all day, because he never knows when somebody might do some really serious traumatic thing, you know. So they're very nervous about this, and the quicker you can relieve their nervousness and just be a regular person and let them realize you're just going to talk in a plain and common voice, the sooner you're going to be in a communicative situation. Now, obviously, you're going to find out real quick if you got a cooperative officer or not, and if you don't have a cooperative officer, then you're going to be in court anyway. So the best thing I can tell you is be patient. Just let us follow along with our program, and we'll be happy to demonstrate. And again, we would like to let you know that your best defenses are in your Constitution, that Constitution is a viable contract, that it is enforceable in the court of law under the statute of frauds, that you have a right to claim those rights, that the burden is on you to claim them timely, and a key word here is timely, or you lose the right. So you want to be cognizant of your rights and be able to timely speak up. Okay? Now, let's go on to a couple of things here. We're going to concentrate, as we did before, on our main basic cases. We also want to give you some further advanced programming. The book The Federalist Papers by Madison, Hamilton, and Jay. Those are the gentlemen that wrote the United States Constitution. Okay? And you want the Mentor edition because it is the unabridged edition. Now, the Supreme Court has ruled in the case of Cohen versus Virginia. That's recorded at 6 Wheat Reporter, volume 6, page 2. All right? Now, Wheat is an old report, and this was done in 1821, so you may have to go to your leading law library around, like we go to Michigan, University of Michigan, or we go to Detroit College of Law. But you want to these pages will be so old you'll have to worry how you turn them without trying to screw them up. But the Supreme Court ruled in the matter of Cohen versus Virginia, 6 Wheat 2, that this book, The Federalist Papers, was the exact record of the intent of the framers of the Constitution, Madison, Hamilton, and Jay. Those are the guys that wrote the Constitution. So obviously being able to read their published thoughts as they were doing this Constitution is very, very forceful in terms of constitutional interpretation, and the intent of the lawmaker is the law. And it shall be liberally enforced in favor of you. You are the clearly intended and expressly designated beneficiary, got me? So, everything you can do to enhance your position in terms of how your lawmakers thought when they framed this Constitution clearly makes your case even more stronger for the Constitution be interpreted in favor of you. So we recommend you get a copy of this Federalist Papers, you read it cover to cover. You want the Mentor edition because that's the unabridged edition. You'll find some of the other editions got some of the pages pulled out. Okay? Now, we want to get into some of the cases. Basically, the second program that we have here is the advanced section. We are going to be covering procedures. We're going to be teaching you how to be your own counsel. We're going to be telling you some facts and issues on what to do, what happens when you get pulled over, how do you exercise your rights in a timely fashion. We're going to be talking about some of the problems that are going on in America today. We're going to be talking about some of the studies that have been done. We just had a law review study put out by this lady here. Her name is Joyce Lee Malcolm. Joyce Lee Malcolm. She started out working for the anti-gun people. She is a Harvard legal scholar. She is very, very knowledgeable. She researched the right to keep and bear arms of the people back to the 1700s in England. And she came to the honest belief after all of her research, and of course she would be following her research because she is a person of very acclaim in terms of her study. She researched it back to the 1700s and found out that, yep, our right to keep and bear arms is a positive right. It has come from serious law all the way back to the Magna Carta. And she published a book. And the book here is To Keep and Bear Arms. It's a rather extensive book. Okay? It's not hard to get a hold of. It did take us about 10 days of ordering it to get a hold of it. But it's a definitive study on the right to keep and bear arms that verifies the holdings that your average person who's NRA oriented or who basically is constitutionally oriented is going to be happy to have, which is basically the right to keep and bear arms is a protected right that goes back with great legal scholarly study. Okay? So these are a couple things that you can use to help you defend. Okay? We need to understand that at the beginning of every one of these laws, there is an enabling clause that basically says how the law shall be brought into being. And there is an argument that says, okay, that the law that is presently here today is based on some law in the past, okay? And almost on every one of these constitutions, all the way up through our history, through the Articles of Confederation, through the U.S. Constitution, through various state constitutions, they'll have an enabling law in the beginning. And of course, the enabling law just allows them to bring their version of the Constitution of what rights are there today. That the rights that were had before are carried on, plus are further delineated by this Constitution. But at no time do they have a right to abridge the previous document. Now, going all the way back to the Magna Carta, you can see the decisions where it comes down. The Magna Carta, the Declaration of Independence, the Articles of Confederation, the United States Constitution, the Virginia Acts of Concession, the Northwest Ordinance, the Northwest Territorial Government, the Northwest Territorial Division, Indiana, the Indiana-Michigan Territorial Division, the Enabling Acts, and that's what I'm trying to explain to you today. The Michigan Organization and Submitting Alternatives, and the Michigan Assent to Condition of Admission. And then the state of Michigan became a state in 1837. Now this is just from my area, so I'm trying to give you an example. Then we have a Constitution of 1835. We have a Constitution of 1850. We have a Constitution of 1908. We have a Constitution of 1963. Every time one of these constitutions comes by, the enabling acts in the beginning of it state that everything that was before guaranteed is brought forward. Okay? So everything that is before is brought forward and carried forward, and if anything, it's supposed to be made stronger. Okay? It's never made weaker, it's made stronger, or it's equal to. So all of the rights brought forward are carried all the way back from the Magna Carta as a line of succession. So this is how you historically review trends and where, what, and how it comes from, and how authorities are established in law. Okay? Now, the important thing to understand is that we are going to cover procedures. We are back to our normal procedure here. We have our court cases here. We are going to start giving you examples of court cases as we go, and we're going to show you how you can exercise rights. Now, one of the first cases that we are going to bring is basically the right to travel. All right. Now, there's a lot of people that are interested in this particular issue, and license plates and driver's licenses and all this, and you have a lot of programming that's problematic from this, and you have a lot of people that are looking to argue. So we want to share some basic arguments with you. We're going to claim a First Amendment right to travel, and we're going to claim also a Fifth Amendment. It's guaranteed under the Fifth Amendment of due process and equal protection under the law. All right? Now, we come down, we looked up in our state constitution, and this is our Constitution, and basically we have protected a right to travel. Okay? The freedom to travel is a fundamental right that should be unlimited by statutes, rules, or regulations which unreasonably burden or restrict movement. Okay? Now then, a law which substantially affects or penalizes the exercise of the right to travel may be justified only by a compelling state interest and must be tailored carefully to avoid unnecessary infringement on the right. Okay? Now, when we come down here, we start reading some of these arguments. You'll notice these little letters here that say, freedom to travel throughout the United States has long been recognized as a basic right under the federal Constitution. See Note 54. Everybody see this little Note 54 here? Again, we're going to take this Note 54. We're going to come down here. And the very first case that we have is Shapiro versus Thompson. This is recorded at 394. That's volume 394, U.S., page 618. And I just happen to have a copy of the case here. And this is Shapiro versus Thompson. Okay, now the beginning of the case, all right, pull that one up there. The beginning of the case, they're talking about the purpose of inhibiting migration by needy persons into a state is constitutionally impermissible. All right? All citizens must be free to travel throughout the United States uninhibited by statutes, rules, or regulations which unreasonably burden or restrict this movement. All right? If a law has no other purpose than to chill assertions of constitutional rights by penalizing those who choose to exercise them, it is patently unconstitutional. All right, does everybody pick up on the gist of the argument here? Equal Protection Clause prohibits apportionment of state services according to part tax contributions of its citizens. Any classification which serves to penalize the exercise of a right of interstate travel unless shown to be necessary to promote a compelling government interest is unconstitutional. Okay? Now, that's clearly established. Now, we go into the case, we come to find out, it says that the right finds no explicit mention in the Constitution. This is what I was trying to tell you. You got to use a little bit of wisdom. You read between the lines. In other words, what is your right to life, liberty, and pursuit of happiness? What does it mean to you? Think about it. You can look at the exact words. The right of life, liberty, and pursuit of happiness. Ducky, what's that mean? I have no idea. Well, I'm telling you to start having an idea. Because when you have an idea, they got to listen. So you have an idea and you say, I have a right to travel freely and unencumbered, right? Now, that a right so elementary was conceived from the beginning. All right? They're talking about the right to travel. Okay? That a right was so elementary was conceived from the beginning to be necessary concomitant of the stronger union the Constitution created. In any event, freedom to travel throughout the United States has long been recognized as a basic right under the Constitution. We've established that the right is clearly there. So you were right. You had a feeling that you had a right to travel, and you were right. There is such a right there. Okay? One of the ways you could find arguments on that would be to go into the Federal Digest at the local library. Go down by your Supreme Court cases. There'll be a set of red books called the Federal Digest right next to the Shepard citations. You look up the book called Words and Phrases. And in the book Words and Phrases, you ask for the right to travel. It'll give you every Supreme Court case that has anything to do with the right to travel. Okay? One of the leading cases is this case, Shapiro versus Thompson, that it's such a basic right it doesn't even need to be mentioned. Okay? Now, it is important that you be able to back your arguments up. In other words, it's one thing to pick the argument up. Now, here we go. In moving from jurisdiction to jurisdiction, they were exercising their constitutional right, and any classification which penalizes the exercise of the right, unless shown to be necessary to promote a compelling government interest, is unconstitutional. All right? Now, the reality was they exercised their right to timely travel. All right? And the state didn't want to allow that. All right? Now, let's flip back here. I'm going to ask you a series of questions. First of all, the Constitution is the supreme law of the land, right? We established that. Who said so? Marbury versus Madison, 5 U.S. 137, 1803. The Constitution of these United States is the supreme law of the land. Any law in conflicts, null and void of law. Now, we know that the Constitution is supreme. We know that the right is clearly established in Shapiro versus Thompson. Can a state, arbitrarily and erroneously, convert a secured liberty, in this case the right to travel freely and unencumbered, into a privilege and issue a license and a fee for it? Obviously, we have decided that in Murdoch versus Pennsylvania, clearly, no state may convert a secured liberty into a privilege. Now, does everybody see how we plug that in? Just like on your computer, you fill in the blanks. Okay? You have the court case. It says no state can convert the liberty into a privilege and issue a license and a fee for it. Well, what right are we talking about? The right to travel freely and unencumbered. So you plug that in. So does the state have a right to require you to have a license for the exercise of that right? No. Does everybody see that? Now, what happens if the state requires you to have the license? Shuttlesworth versus Birmingham, Alabama. You can ignore the license and engage in the right with impunity. That means they can't punish you. Now, what happens if they pull you over? They give you the ticket. Well, you're going to go to court and you're going to fight it. You're going to file a brief. We're going to show you how to do that at a later time. We'll show you exactly what to put down there. But these are the cases you're going to be putting down on your memorandum of law as to why you have a reason to feel that you're right. First, that your constitutional right is superior to any law that they would put down. You have that right, and they can't pass a law that takes away that right. Secondly, if they do, it's unconstitutional. Thirdly, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, you can ignore the license and the fee and engage in the right with impunity. Shuttlesworth versus Birmingham, Alabama. And since you have not willfully done anything evil, you have relied on your Constitution and on the Supreme Court decisions, you have a perfect defense to the charge of willfulness. So you could not have been charged with willfully not going and getting the license. Does everybody see that? Okay? You have a perfect defense. United States versus Bishop, 412 U.S. 346. Defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, you didn't do that, did you? Because you have a perfect defense. You relied on previous decisions of the Supreme Court, Shuttlesworth and Murdoch and Marbury. You relied on your constitutional right to travel freely unencumbered, pursuant to Shapiro versus Thompson. So you have a perfect defense. So now where are we at? Your Honor, may it please the Court, I motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted, and I would like to motion to dismiss, and I'd like my costs and fees for having to defend this frivolous case. Now, you have a right to collect your time for going to court, all right? You submit your bill, you submit your proposed order, you fill out your own proposed order. That makes the case go faster, and the judges kind of like that, and it intimidates the hell out of the prosecutor when you do your own order. Now, let's say, well, that's how you interpret that, sir. That's right, sir. That is how I interpret it. And 16th Am Jurisprudence, Section 97 says that it shall be interpreted in my favor because I am the clearly intended and expressly designated beneficiary to citizens for the protection of rights and property. See Briars v. United States, 273 U.S. 28. Unlawful, and that deals with an unlawful search and seizure, but it also deals that it's supposed to be interpreted in favor of you, the clearly intended and expressly designated beneficiary for the protection of your rights and property. So they got to enforce it in favor of you, right? Now, Boyd v. United States comes next. The court is to protect against any encroachment of constitutionally secured liberty. It's their duty. They have no choice. They have to do it. Okay? All right? In Norton v. Shelby County, an unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protections. It creates no office. It is in legal contemplation as inoperative though it had never been passed. Now, after you write all of this stuff down, you casually say, wherefore, Your Honor, I pray before this honorable court for your just and lawful relief. I ask that you dismiss this case with prejudice for failure to state a cause of action for which relief can be granted, and I pray the court for my just relief for having to defend this patently frivolous and spurious case, and my costs are whatever they are. You submit that on your order. I have an order. I have a proposed order, Your Honor. It's in my brief. At that point, they will turn to the prosecutor and say, well, Mr. Prosecutor, what do you think you'd like to do about this? And most of the time, they're so overwhelmed at this point that they just go, I'll go for the dismissal, Your Honor. And the judge will give them some slack. Well, never before was a young man, not attorney, so literally overwhelmed when it counts for the prosecution, a licensed attorney. Now, it's not my goal to make attorneys look bad. My goal is to make you look good. My goal is to make you understand your Constitution. Now, if you happen to do it and you do it better than the attorney, God bless you. And God bless America. And if the attorney doesn't do his homework and prepare his case, I have no sympathy for him. Because he shouldn't have done what he was doing anyway. And if he'd had any brains, he'd have pulled you aside and he'd have done what other attorneys have done to me and said, you know, I hate going against the pro se litigant attorney. Almost always they're really, really good. And, you know, I never get to find out if they're really, really good or they're really, really bad until I show up, and then it's too late. So I'm already on the diving board. And either the pool has water in it or it doesn't. And usually it doesn't. And it hurts when you hit the bottom. So, they don't like going against you people. They will not like going against you. If you halfway know what the hell you're talking about, they're going to be intimidated. And I can tell you many, many, many tales. I had this one gentleman, he didn't have any plates on his car, and they called him into the court. And he was standing in the hallway, and the prosecution said, would you come over here, sir? I'd like to talk to you. He came in the office, and he sat down. And this party said to the prosecutor, what can I do for you? And the prosecutor said, sir? He said, what can I do for you? He said, well, it's not what you can do for me. I'm the prosecutor. What do you want to do in this case? Well, I assumed there was something I could do for you. You called me in here. Well, what do you want to do? How do you want to plead on your case? Well, I don't intend to plead, sir. I intend to answer in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction, because that's an issue to be brought up in my pleadings and briefs to file with the court. The guy's mouth was on the ground. He said, are you an attorney, sir? He says, no, I'm a truck driver. The guy absolutely was in a panic. I had the same gentleman, later he was working as a bricklayer, and he did the same thing. Told the prosecutor he was a bricklayer, and the guy's jaw was on the ground. See, they don't anticipate that people that are in other jobs other than theirs have any brains. And it blows their doors off when all of a sudden this bricklayer or this truck driver can come in and argue law, and all of a sudden it's like shoot, this guy's good. I have to treat him like he's an attorney. So what did this guy do? The first thing he does out of the chute, he walks up to the judge and he tells the judge, he says, Judge, I'm going to dismiss this case. Because he realized he was going to get hammered. And my guy says, he can't do that. I took day off work to come over here and battle. I told him, I said, shut up, sit down and relax. You won. Don't say nothing. You won. And the judge broke out laughing because this guy didn't want to quit. The judge turned to him and he said, well, evidently the prosecutor doesn't want to proceed, sir. I'm going to have to dismiss the case. He is the complainant. Can he do that, Judge? He can't do that. I'm here to battle. I want to go. Let's do it. And the judge laughed again. He says, well, apparently, sir, I cannot sustain a complaint that is not properly before the court. Counsel for prosecution has entered a motion to dismiss, and I have no other option but to dismiss. Now, if you want to countersue him, that's another case. Well, I'll do that. I'll do that. In the meantime, I told him, will you be quiet and submit your bill? Submit your bill. You won. Submit your bill for your damages. So he did. He said, well, I'll submit my bill then, Your Honor, for my costs and fees for having to defend this frivolous case. And the judge smiled, because people don't usually do that. But if you win, they are required to pay you. That's the rules. If you lose, you pay. So the bottom line is this. When you file your papers and they turn around and you get a win, make sure you got your little bill in there for your lost time from work, or any copies that you had to make, or any visits to the law library, or any what is called real and personal damages. And don't pad the account. Put down exactly what you got, because if they force you to prove it, you can get busted for perjury. So I don't recommend you shall we say, stretch the pad. I recommend you put down exactly what your costs are. Believe me, the fact that they got beats plenty enough of a sting, and the fact they got to pay a couple $100 for your lost day at work will be more of a sting. And you will get a code on your license, and the next time you get pulled over, they will just hand your license back and tell you to think about slowing down and have a nice day. Because they don't like people like you. Because you're an American. And Americans don't give up. They never surrender, and they fight. One judge told me one time, he said, you got any kind of idea how much money you cost this court today? And I said, I hope it was a bunch, Your Honor, because I hope you got to go write a whole bunch more tickets to break even. The way I figure, the more tickets you got to write, the sooner the public's going to wake up to this theft, and maybe they'll start doing something positive to stop this kind of stuff, because it's my belief they should be having masks on out there, because, I mean, if they was an honest crook, they'd be having a mask on there when they robbed the people. Okay? Well, he didn't like that answer too good, but the bottom line is he knew I was right, and after a while they realize what your goals are, and they know, hey, this is more fun than Edgewater Park, and I want to go on all the rides twice. You know what I mean? I want to hit the Wild Mouse and a whole bunch of them other rides. Let's do it. And see, when they see that, they realize there's no point. You're not going to learn anything. You're going to cost some time, money, and materials. Now the system is not profitable. Okay? So they back off. They put a code on your license. They won't bother you anymore. Now, did everybody see we take that line down? We take the line from the Constitution. We take the line from the right. Now let's think up another right. How about the right to work? Contract your labor and your skill and your time of life as you see fit. Now, your right to work is protected by the Constitution under the First Amendment. Again, you have a right to work and contract your labor and your skill and your time of life as you see fit. I get hauled into court before the chief judge of this big court here in Oakland County. I won't give you the judge's name because he was a fair judge and a good judge, and I'm going to let him slide. But the bottom line is this. He looked just like Abe Lincoln. I mean, exactly. He was the spitting image. And he leans over the chair and he says, well, he says, it's been reported to me, son, that you don't have a license to practice law. Is that correct? And I looked up at him and I said, Judge, I'm not practicing. I know what the hell I'm doing. And the whole court broke out laughing. He said, that's pretty good. That's pretty good. I like somebody with a sense of humor. He said, but that doesn't change anything, son. You have to have a license to practice law. And I said, Your Honor, I'm an unfranchised common law free man. I live at the common law. I am not a participant in any tontine schemes of limited liability on a joint venture for profit with an insurable interest requiring me to participate in these illegal corporate Ponzi schemes. I am just Joe Blow from Kokomo down on the street. I just live at the common law. And I have a right to work and contract my labor, my skill, and my time of life as I see fit, not as some third-party arbitrary and capricious bar association sees fit. And they had loaded the court with all these attorneys, and they was, oh, you hear that guy? I said, Your Honor, the state of Michigan arbitrarily and erroneously converted my right to work into a privilege, and issued a license and a fee for it. That's unconstitutional, Your Honor. Marbury v. Madison, 5 U.S. 137, 1803. Anything in conflict or repugnancy is null and void of law. Okay? Can you see that? Marbury v. Madison. And since the state converted my right into a privilege and issued a license and a fee for it, Murdoch v. Pennsylvania, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth v. Birmingham, Alabama says I may ignore the license and the fee and engage in the right with impunity. That means you can't punish me. And U.S. v. Bishop, 412 U.S. 346 defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. I submit, Your Honor, I couldn't have done an evil task because I was totally following the Constitution and the U.S. Supreme Court. I would submit that prosecution counsel's burden is to prove that I did willfully and knowingly avoid a known duty or task under the law, namely to get the license. And I would submit he specifically precluded he cannot perform his task, and therefore I'd motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous, spurious complaint. The judge rolls back in his chair with a great big smile, and he turns to counsel for the prosecution. He says, "Well, Mr. Rose, what do you think we ought to do about this young gentleman?" The prosecution bounced back. "How about we honor the motion to dismiss, Your Honor?" The judge says, "Good answer, because I don't think you're ready for this kid today." And the whole court broke out laughing. An old gentleman walked up to me and he said, "Son, I just want to shake your hand and tell you, you got to have like King Kong, because you just slammed the Bar Association right into the ground. On top of that, I've been an attorney for 57 years, and I just want to shake your hand, sir, and tell you that that was one of the most magnificent arguments that I've ever had the privilege to hear in a court of law." Now, he was an honest attorney, and he realized what kind of a chain was around his ankle with this Bar Association. And these lawyers, they resent that. They really do. They're people just like you. They don't like to have any chains on them. But they hadn't had anybody quite show them how to get those chains off. And when they saw somebody do it in their own skill, with their own, with their own cards, on their own playing field, it actually impressed the hell out of them. I had several gentlemen come up and shake my hand that day. Needless to say, the case was dismissed, and I've been helping little people getting jammed for years. Every time I see some little person get jammed, I'm out there flipping that wrench. Zingy, zingy, zingy. And I flip that wrench on them so good that usually they just back off. Dr. Kevorkian was a perfect example. The poor man was just trying to help these poor people. They were jamming him every which way but loose. So what we did is we taught him a thing called quo warranto. I got a hold of his attorney and submitted all of the arguments. Let me bring that up here. Quo warranto. You brought it in here. Let's see. Just a second. Can we go to a pause here for just a second? Oh, wait. Here we go. There we go. Quo warranto. Let's bring that up next. All right. Now, we're going to bring up several arguments right here. We're going to bring up police powers, and we're going to bring up quo warranto. Quo warranto is a basic right that goes back to English law, ancient English law. Okay, here it is right here. All right, quo warranto. Let's read it. Quo warranto. In Old English practice, a writ in a nature of a writ of right for the king against him who claimed or usurped any office, franchise, or liberty, to inquire by what authority he supported his claim in order to determine the right. It lay also in the case of a non-user or long neglect of a franchise. Franchise is corporation. Or misuser or abuser of a franchise, being a writ commanding the defendant to show by what warrant he exercises such a corporate franchise, having never had any grant of it, or having forfeited it by neglect or abuse. A common law writ designed to test whether a person exercising power is legally entitled to do so. An extraordinary proceeding, prerogative in nature, addressed to preventing a continued exercise of authority unlawfully asserted. Johnson versus Manhattan Railroad Company, New York, recorded at volume 289, United States, page 479. Now, it is intended to prevent exercise of powers that are not conferred by law, and is not ordinarily available to regulate the manner of exercising such power. Now, what we did, see, police powers are defined as the right of eminent domain of a state or political subdivision to enact laws for the common good and welfare. Let's pull that out. Police powers. Everybody got that? Police power, right here. Let's do police power. Right here. Police power. This is out of Black's Law Dictionary, folks. An authority conferred by the American constitutional system in the 10th Amendment, U.S. Constitution, upon the individual states and in turn delegated to the local governments, through which they are enabled to establish a special department of police, right? Such laws and regulations as tend to prevent the commission of fraud and or crime and secure generally the comfort, safety, morals, health, and prosperity of its citizens by preserving the public order and preventing a conflict of rights in the common intercourse of the citizens, and ensuring to each an uninterrupted enjoyment. Everybody get that word, enjoyment? Of all the privileges conferred upon him or her by the general laws, the Constitution, the power of the state to place restraints on personal freedoms and property rights of persons for the protection of the public safety, health, and morals, or to promotion of the public convenience and general propriety. The police power is subject to limitations of the federal and state constitutions, and everybody catch that, and especially to the requirements of due process. Police power is the exercise of the sovereign right of the government to promote order, safety, security, health, morals, and general welfare within constitutional limitations, right, is an essential attribute. Marshall versus Kansas City, Missouri, recorded at 35 volume, Southwest 2nd, that's another reporter, Southwest 2nd, page 877, all right? Now, police powers are the right of eminent domain of a state or political subdivision to enact laws for the common good and welfare and to curb crime within constitutional limitations. And the key words in that whole thing are within constitutional limitations. And then it tells you to see the 10th Amendment. And when you see the 10th Amendment, and believe it or not, you can go look up the books, and it divides the 10th Amendment real. Here, pull over here. All right. The burdens placed on the national government as a result of states' regulation, regulation of their internal affairs, save as Congress may act to remove them, constitute normal incidents of operation within the same territory of a dual system of government. And no immunity of national government from such burden is to be implied from the Constitution. All right? All right, Penn Diaries versus Milk Control Commission, all right, a Pennsylvania case, recorded at volume 318, U.S. 261. The people of the United States residing within any state are subject to two governments, one state and the other national. But there need be no conflict between the two because the powers which one possesses, the other does not. That's United States versus Cruikshank, a very famous Supreme Court case. Excuse me. Now, we come over here. Within the area of delegated powers, expressed or implied, this amendment does not reduce the powers of the United States. That's U.S. versus Manning. Recorded at 215, Federal Supplement, that's another reporter, page 272. The Federal Union has only those powers expressly conferred on it and those reasonably implied from powers granted, while each state has all governmental powers except such as the people by the Constitution have conferred on the United States, denied to the state or reserved to the people themselves. Anderson versus Gladden, recorded at volume 188, Federal Supplement 666. That's a bad number. All right? It is when federal legislation attempts to confer power upon the national government that it is not within the express or implied powers given by the Constitution that the legislation becomes vulnerable to this amendment. Okay? Now, what are we talking about here? Brady Bill? Huh? They're not within their powers. They have no 10th Amendment powers to take away the Second Amendment. Does that make sense to everybody? They don't have any powers. to go and take away the Second Amendment or any other amendment. The Fourth Amendment, the Fifth Amendment, nothing. And the Ninth Amendment precluded them from adding on to the Constitution in such a way that would take away the powers. So by the Ninth Amendment and the Tenth Amendment, they're totally locked out from doing a lot of the things that they do. But see, you got to know that and be able to timely exercise it. So it's very important to understand your Tenth Amendment powers. Now, when in the course of human events it becomes necessary and proper, and this is what we did. This is what we did to help out Dr. Kevorkian. We made sure that his lawyer got this knowledge. We went in there and we dug up a writ of quo warranto. A writ of quo warranto. Alright? Now, this doesn't look like much, but let me tell you something. What we're talking about doing here, see, most cities, at least in the state of Michigan, are by Public Act 230 Public Acts or Public Act 287 of Public Acts, and in every one of them there is a Rights and Powers section. Usually it's recorded at 2.2 or 3.1, and it basically says, and I quote, "Subject to the Constitution of the United States and the general laws of the state of Michigan, the city of or the township of has rights and powers too." And then it starts listing the rights and powers. Right to have a police department, right to have a fire department, right to have a city hall, right, and it starts listing all these powers. Now, the antithesis to the argument is that if they're not within the Constitution of the United States and the general laws of the state of Michigan, they don't have any rights and powers. Does that make sense to everybody? In other words, they're in violation of their corporate charter, their franchise. They promised they would be within the Constitution of the United States and the general laws of the state of Michigan. Now, a lot of people, they don't understand the power of this argument, so I want to really push this one home. I want you to understand. Whenever these little townships and these little cities and what have you, they start acting like King Farouk and that you don't matter and that they don't got to listen to you, this is what I want you to do. You ask them a pointed question and ask them, are you violating my constitutionally secured civil rights by however you claim they are? Because if you are, you have just waived your right to be the city of. And they'll laugh at you for a little bit, okay? Then you explain to them Public Act 230 of Public Acts, which states the Rights and Powers section, subject to the Constitution of the United States and the general laws of the state of Michigan. You have rights and powers. The antithesis to that argument is if you're not going to be within the Constitution of the United States or the general laws of the state of Michigan and you're going to violate my constitutional rights and trample my rights, what we're going to do here is we're going to go for a writ of mandamus in quo warranto. Well, that's a legal term, fancy legal term. But it is an ancient law that goes way back to England in the ancient times. And basically here is a judgment and a capious action for it, alright? You put down here the case. The case came on regularly for trial before the Honorable, and you put the judge's name in there, whatever it is, on a jury trial or non-jury trial, dated such and such. The name appeared as for your counsel and the name appeared for opposing counsel, right? The court heard the testimony and examined the proofs offered by the parties. The court considered itself fully advised in the premise filed in its findings of fact and conclusions of law, and directed that judgments be entered in accordance with such findings, right? Which means they figured out that they violated your constitutional rights. They didn't have a right to violate your constitutional rights, and in the hearing you showed they violated your constitutional rights, and the judge figured out they violated your constitutional rights. So now, for your prayer for relief, we're going to get this quo warranto. And this is exactly what happened to the Honorable Dr. Kevorkian. You'll notice that he was in jail and they were hammering the tail out of him. The next thing you know, everything got real quiet. Nobody said nothing. And then the next thing you know, they were letting him go and they were minding their business. Now this is how it happened. It is therefore ordered and adjudged and decreed. 1. Defendant corporation, the city of, you put down what name, has violated provisions of the act under which it was created, and also has violated provisions of Public Act 230 of Public Act Section 2.2 Rights and Powers section. In other words, it didn't uphold the Constitution of the United States or the general laws of the state of Michigan. Defendant corporation, the city of, whatever, Pontiac, whatever, accordingly has forfeited its charter and become liable to be dissolved by the abuse of its power. How much money am I talking about here, folks? We'd be in about 9 decimal places plus, wouldn't you, don't you think? Now, do you think they're going to bother some little doctor when they're looking at shutting down a major city? What do you think's going to happen? Everything's going to get quiet and they're going to let the good doctor go. Same thing for you. Now, defendant corporation, you name them, therefore is dissolved, and the corporate rights, privileges, and franchise of defendants are declared forfeited to the people. Defendant corporation, you name them, as trustees, directors, managers, and other officers, attorneys, and agents, are forever restrained and enjoined from exercising any of the corporate franchise powers, rights, and or privileges previously exercised by defendant said city, and from collecting or receiving any debts and or demands belonging to or held by defendant city, whatever, and from paying out or in any manner interfering with, transferring, or delivering to any person any of the deposits, money, securities, property, and effects of the defendant city or held by it. You name a trustee, which the state would do, probably the Attorney General, after your complaint is filed, is appointed receiver of all of the property, real and personal things in action and effects of defendant city corporation held by and vested in defendants, or in or to which defendant may be in any wise interested or entitled thereto. Plaintiff, the people of the state of whatever, that's us, state of Michigan, shall recover of defendant corporation, whatever city of, the sum of damages, real and personal. Got me? They don't like that when you start talking that, because they can go 100 million, 3 times that amount punitive damages. They get a little upset. As costs and disbursements of this action, and the receivers is directed to pay this sum out of their pocket to whoever, the Attorney General, but you can have a person stipulated on there as an injured party. Now you put down there the Honorable Judge so-and-so presiding, the date entered, and he signs that, and that city is no longer a city. You see, when they violate your Constitution, this is one of the most powerful tools that you can use. And when you jam this on, you better wear a bulletproof vest to court, because you're probably going to get shot at by the time you get home. But it's nice to threaten. You know, you just threaten. Just drop one of them in the mail and say, if I don't get reasonable cause for my action in the near future, you're going to get one of these in the mail for real. Here is a summons for quo warranto. This is for the start of the thing. Right here. Summons. Form 41. By the way, you can get this in 21 AM Juris Forms and Practice. Your practical forms and practice. Alright? You name the party, you put down there who you are, the people of the state of Michigan versus, you are summoned to appear before which and which court on such and such a date to show by what authority you claim to have, use, and or enjoy the rights and liberties and franchise, namely the corporation city of, set out and complained of in such and such a time, summons, and further to do and receive all things which the court shall then order concerning you. This is kind of like pulling their driver's license for drunk driving. Now that's an oversimplification, but sometimes these city halls operate like a drunken sailor. And they just think they can abuse citizens' rights and trash them. You know who I am? No, and I don't care. You know who I am? I'm your boss. I'm the people. You're elected to work for me. And I'm trying to be nice, so I'd appreciate it if we can sit down and work this out. But if we can't work this out, I'm going to sock it to you, baby. You got me? And that's basically how I feel about it. Now, we can get into some of these other things. Right here. This is a very important point. I'm trying to get this across to people, and you try and tell them, and they kind of look at you with this blank, starry-eyed look. But in the Constitution of the state of Michigan, the latest and greatest, the very first thing they talk about, notice it says Section 1. All political power is inherent in the people. Government is instituted for their equal benefit, security, and protection. Now let me ask you a question. Do you feel equal benefit? I don't. You know? Equal protection and discrimination. No person shall be denied the equal protection of the laws. Right? Nor shall any person be denied the enjoyment of the civil or political rights, or be discriminated against in the exercise thereof, because of religion, race, color, or national origin. The legislature shall implement this section by appropriate legislation. You know? And they start going down through all freedom of worship. You know? I mean, this is what we're talking about here, folks. You know your rights, you got them. You don't know them, you don't got them. We get back in here to police powers generally. This is something you got to understand. Generally, the police power is the exercise of the sovereign right of the government to promote order, safety, and health and morals, and the general welfare of the society within constitutional limits. Within constitutional limits. Did everybody hear that? Within constitutional limits. Generally, the police power is the exercise of the sovereign right of the government to promote order, safety, health, and moral, and general welfare of the society within the constitutional limits. As otherwise stated, the police power of the state is a power or organization of a system of regulations to foster the health, order, and comfort of the people, and to prevent and or punish injuries and offenses to the public. Right? But it has to be within constitutional limitations, and it embraces all rules for the protection of life, liberty, and property. I mean, that's a contradiction of logic today, folks. That doesn't happen. You and I both know it. I mean, who are they kidding? They ain't kidding me. Okay? So, it's up to you, and it's up to me. And we got to get a hold of this book right here. You get a hold of this Constitution, and you start learning that Constitution, and you quote a chapter and verse, and guess what? You'll notice a unique, different change. One, after a while, they start to listen. And you actually affect what is called positive change. And every time they see you, in that goofy hat you wear, they go, oh, for God's sake, don't give that guy no ticket. I have actually been pulled over, listening to the program, didn't have no plates on my car. Policeman called, he says, you got positive ID on the guy? And a friend of mine was taping it off his police radio. He said, yeah, it's him. He said, well, for God's sake, don't give that guy no ticket. And the guy says, Sarge, he ain't got no plates on his car. I said, I don't give a damn what he ain't got on his car. Don't give that guy no ticket. He said, but Sarge, he told me he's just been waiting to fight it and beat it all the way to the Supreme Court, and I wrote that on the ticket. He says, you give that guy a ticket? I said, I just told you not to give that guy a ticket. What are you, deaf? You got some problem with your hearing? He said, I told you not to give that guy a ticket. Now, why did you give that guy a ticket? He said, Sarge, he ain't got no plates on the car. I said, I told you I don't care what he ain't got on the car. This is all recorded on a radio broadcast. So everybody was laughing. The police were laughing. Everybody was laughing. His buddies were laughing. They were ribbing him over the radio. The sergeant told him, all right, knock it off. Clear the net. This is serious. He said, fine. He said, you give him a ticket? He says, fine. He says, tomorrow morning at 9 o'clock, I want you to be in here when the city attorney comes in here. And he says, you're going to personally deliver the ticket to him, and he ain't going to be real happy with you. Because he hates that guy. Every time he goes to court, that guy blows his doors off. He looks like a fool. You give the guy a ticket. Now he's got to go to court. So sure enough, we go to court. Come up before the court. Judge starts operating like a prosecutor. He starts asking me all kind of discovery questions. I call it as soon as they call the case. Now this is something important. You got to understand. You're going to be your own attorney, then you got to know all of the programming. When you hear him call your case, you get off your tail feather and you run right up there as quick and as expediently as possible without knocking anybody down. And you say, ready, Your Honor. You state your appearance. I'm so-and-so, hearing before this honorable court. I am standing as my own counsel. In my state, it's under Article 1, Section 13. I've appointed myself my own attorney, and I'm ready to proceed with my administrative and procedural matters. And at this time, Your Honor, may it please the court, I motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted. Bingo! Now, I apologize if I'm talking too fast. I'm going to try and slow down a little bit, but when you're in court as much as I am, you just learn. You either talk fast or you lose. So I apologize if I'm going a little too fast. I'm going to slow down. I'm trying to make it easier for you folks, okay? But the judge bips off right away. Well, you got a ticket on such and such. I said, whoa, Your Honor. I said, are you the judge, the disinterested third party that's trying this case? The trier of fact? He said, yes. I said, okay. I said, is this the prosecutor over here to my right? He said, yeah, that's him. I said, okay. I said, are you going to prosecute this case, Your Honor? He said, no, I'm the judge. I said, and why are you asking discovery questions? Well, I just want to find out what's going on. I says, isn't that his job over there? That's what he's supposed to do. He's supposed to present his case as the prosecutor, trier of the case. You're the trier of fact, he's the trier of the case. I said, if you're going to operate as the judge and the prosecutor, I'm going to object on the record as a mistrial. He said, okay, I'll let you enter that on the record. Go ahead. I said, okay, let it be entered on the record as an appealable issue. He said, okay. He said, now it's on the record. He said, let me ask you this. You get a ticket on September the 30th? I said, yes, sir. He said, well, let me ask you this. Do you have any plates on your car? I says, no, sir. And I don't intend to get any. And of course, all the people in the court, oh, this guy's going to jail. Watch this. This is going to be good. He says to me, he says, I assume you have a very good reason for that. And I said, yes, sir, and I shut up. I waited. He said, can I hear it? I said, well, Your Honor, I said, I'm an unfranchised common law free man. I'm not a participant in any tontine schemes of limited liability on a joint venture for profit with an insurable interest requiring me to participate in these corporate Ponzi schemes. I'm just a little Joe from Kokomo. I live on the block. I travel at the common law. And I have a right to travel freely and unencumbered pursuant to Shapiro versus Thompson, and that right is so basic it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously converted my right into a privilege and issued a license plate and a fee for it. Murdoch versus Pennsylvania says no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth versus Birmingham, Alabama says I can ignore the license and engage in the right with impunity. That means you can't punish me. Since I have relied on previous decisions of the U.S. Supreme Court and on constitutional defenses, I have a perfect defense for willfulness. I am immune to the prosecution. Therefore, prosecution counsel does not have a cause of action for which relief can be granted. I'd motion for dismissal with prejudice for failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous case. The judge starts reading the ticket. Told officer he'd just been waiting to get this ticket so he could fight it and beat it all the way to the Supreme Court. He laughed. He says, motion granted, and he ran off the bench before I could get my damages. So I went out in the hall. He went to the can. I waited for him. He came out of the can. I served him with my papers. He said, you didn't have to do that. I said, well, I didn't want you to be inconvenienced, Judge. He said, okay. He signed. I went back in the court as a casual thing just to see what kind of reaction would happen, and I sat down. About 2 cases later, this elderly gentleman gets up, and he stands up there, and he says, Your Honor, I'm not quite as knowledgeable as that young gentleman that was here just 2 cases ago, and I don't presume to understand all of the issues that he raised. But it really sounded good to me, and I'd kind of like to ditto everything he said on top of my case. Everybody broke out laughing. The judge says, all right, how many guys here didn't have no plates on their car? About 5 guys raised their hand. He says, okay, everybody dismissed. Get the hell out of here. And everybody broke out laughing. It was like, you know, at the carnival on Christmas or something, you know. It was a carnival atmosphere. So I'm telling you, you can affect change. And see, they had all figured. They said, watch this guy's going to jail. And then all of a sudden, boom, out jumped. And I mean, I'm telling you, it's this little book right here. This book. You know what's in this book, you have power. Knowledge is power. You know what's in this book, and you know how to exercise your rights in a timely fashion. You have constitutional rights. And if you exercise them, and you utilize good judgment, and be courteous, and just treat people the way you like to be treated, with a little dignity. Most of the time, 99% of the time, I win. Now, I will tell you, I've been to jail. I mean, I'm not going to lie to you. But when I go to jail, they really hate it, because I usually get, the last time I got 5 guys' cases retried, and I got another 4 guys out, like within 24 hours, and then I got 11 guys off of their case because they signed up for drug rehab. And one bank robber come up to me and said to me, I think you know I'm a hard case. I said, yeah, I kind of gathered that. He says, I want you to know you changed my life. He said, I really appreciate you helping me with my paperwork. He says, they're going to give me a new chance. They're going to let me out on probation. I'm going to marry my girlfriend. And he started crying, and he basically said, I'll never forget you, Pops. He says, you're some kind of guy. He says, God bless you. And he says, I want you to know I really appreciate what you did, and I found God too. And between you and Crazy Charlie, he said, Crazy Charlie is a minister that goes around to all the jails. He used to ride for the outlaw motorcycle gang. Crazy Charlie is clearly crazy. The last time I saw Crazy Charlie, he was riding down 8 Mile Road at 85 miles an hour, standing on his seat against another guy, standing on his seat to see who was going to wimp out first. Crazy Charlie did about 5 years in the slam because he got charged with murdering some guy. Crazy Charlie went to jail and he found God. And God spared Crazy Charlie from a life sentence in jail, and Crazy Charlie owes it to God, and he goes through all of the jails and he preaches the gospel. And he basically is quite a gentleman, and he's nobody to screw with. And when we went to chapel, the kids were all joking around. Pops, you going to chapel? I said, oh, hell yeah. He says, Pops, you're a badass. What you want to go to chapel for? I said, let me tell you something, my man. You can always learn something, and I'll tell you. one of the best places to learn it is at chapel. So why don't you come on down and you might learn something. We go down there and who do I see? Crazy Charlie. I hadn't seen Crazy Charlie for years. He looked at me, I looked at him, he said, what the hell are you doing here? I said, I don't want to talk about it, Crazy Charlie. The guy turns around to me, he says, Pops, is there anybody in this joint you don't know? I says, I'll tell you what, this guy is a guy I would listen to. Because he's serious. The man is serious, and he found God, and he's going to try and help you find God. And in the end, you will have peace. Well, with this gentleman, this one bank robber, found this gentleman, and between myself and Crazy Charlie, he found God, and I wish you could see the peace on his face. He was in a lot of trouble. And we did his paperwork for him. We helped him, and basically they redid his whole program, and because he found God, they decided to put him out on lifetime parole. He made restitution. He gave the money back. He changed his whole life. His whole life was changed just from that instant. So I'm telling you, when I go into jail, it's hilarious because it's like the jailers don't even know how to act. And it's like, the one jailer told me when I left, he shook my hand, he says, I'm going to miss you, Pops. He says, they call me Pops because I'm older. I was a little teed off when they called me Pops the first time, so I told this kid, he said, I said, what's with the Pops? I said, I'll bet you can't even do 25 push-ups. He said, you're probably right, Pops, can you? Boom, down I went, 25 out, and here's, I'll raise your 25, and here's another 25. He said, Pops, you in good shape. I said, I'm going to show you how good a shape I'm in, you keep calling me Pops. He says, no, you don't understand, Pops. He said, if you're an older gentleman in the joint, they treat you with courtesy, they call you Pops. That's just out of courtesy. I said, oh, I guess you can call me Pops, and that's cool. So don't you ever think that I'm getting old. So I'll fool you. So they laughed. When I left, they lined up to shake my hand, and even the jailer said he was going to be sorry to see me go because I was helping so many people, and people were getting their lives together. And so when I go to jail, it's kind of unique. I actually get a vacation. I got the top bunk, and I laid on the window and let God's sun shine in my face, and I got a suntan. And guys would say, Pops, why do you climb up on the top bunk? I says, man, I'm out on the beach getting sun and rays. What are you doing? He said, you know, Pops, you something else. You're going to make, you in jail, and you're going to make, I said, I'm laying out here on the beach. What you talking about? I'm laying on my bed right next to the window, and the sun comes right through, and I'm on the beach. What you talking about? Getting a suntan. So you got to make the best of where you're at, no matter what. It keeps your spirits up. And the bottom line is this. I wouldn't have been in jail if I could have more effectively argued my Constitution. I ended up having to do a brief from the jail, 28 pages. I sharpened the pencil on the phone on the wall. Here it is. This is a 28-page motion to dismiss. No, this is more than that. This right here. I mean, this is all from hand, longhand. And when we got to court, the judge looked at it. He goes, sir, are you an attorney? I says, no. He says, you ever been to law school? I says, no, sir. He says, you did this from jail? I says, yes, sir. He says, you did this from jail from memory? I says, yes, sir. It's rather extensive. It's huge. Meanwhile, the prosecutor kicks in. She says, Judge, do I got to answer this? He goes, oh, hell yeah. This guy is kind of like this guy on Night Court on TV and Channel 2, kind of flippant. And he says, oh, hell yeah, counselor. He says, what's this, a new hobby you just took up? He says, this guy even did his own proposed order. I don't even have to fill out an order. And he says, not only that, I want it done by 8 o'clock Monday morning. So all weekend she had to go to the law library and answer all this stuff. She was not a happy camper. So then she proposed that I have to have a shrink check my bolts out to see if my batteries are charged. Because if you defend your Constitution, you got to be a crazy turkey. And she found out I'm pretty well squared away. I just argue my Constitution. I asked the judge, I says, has it gotten this bad yet, Judge, where they got to toss you in a nut house because you defend your Constitution? He says, not in my court. Okay, we got a question here?
I've heard tell of people raising the, saying they want to base their argument on the Constitution, right? And I've heard of judges speaking up and saying, well, the Constitution has no place in my courtroom. How can they even think about that?
Boy, that is a very serious statement. Because what that judge just did in an open court of law under Title 18 United States Code Section 2381 is he just committed an act of treason. See, the judge is sworn under Article 11 in this state, Paragraph 1, that he will uphold the Constitution of the United States and move as most immediately as is practicable to defend the Constitution, and a violation of that act would be capital felony treason under the people and government of the United States of America, and he would be subject, upon conviction, to be hung by the neck. That's how serious.
If the defendant had a driver's license and they were trying to argue a traffic matter and they were kind of in the system already and raised a constitutional objection that the judge might say it doesn't apply?
Well, here's how we start a lot of these traffic cases, and I'll get right into that. The issue, when you first walk before a traffic court, you see, when they merged these courts together in 1963, they screwed up. They wanted to lay off half the judges, see, and they only wanted to have one building. So what they did is they merged the traffic court per se, or that docket, into the criminal court docket. And when they did that, they didn't check the rules, you see. And when they didn't check the rules, they didn't allow for jurisdictional challenges between the two courts. So what happens now is you come before the court, and there's several ways you can come before the court. Now, this gentleman here is correct. When he's talking about you have a driver's license, you have entered into a contractual relationship with the state. In other words, it's not a lawful contract because you cannot enter into an unlawful contract. You understand? It is a contract, though, because it's recognized as a contract. Because you have voluntarily entered into this contract, you agreed to all of the rules in their law book for that contract. Now, this is what we call admiralty and maritime jurisdiction, or artificial jurisdiction. And it's a rather heavy argument going into Erie Railroad versus Tompkins and McCulloch versus Maryland, and we'll go into that in depth at the end of this program, but I wanted to share with you briefly. When you sign your driver's license, and especially today, and your voter's registration card, you will notice a little note right under your signature where you agree to the acceptance of the duality of citizenship of not only at the common law, but you accept the national jurisdiction under admiralty and maritime jurisdiction, which allows you to be sucked into all of these uniform commercial code requirements. And this is a very serious thing you're signing here. You don't understand it, but you just sold all your constitutional rights down the sewer when you signed that document. So when you sign it, my honest advice, and this is from experience, you sign the thing, and right at the end of your name, you write UD. U period D period at the end of your name, and underneath your name you write 1-207 without prejudice. Now what that does, it says, I'll be glad to accept your ridiculous privilege. I don't really need to, but I will just to keep myself from being in trouble with the cops. And I'll tell you what we'll do. We'll exercise our Uniform Commercial Code caveat that allows us to keep all of our constitutional rights. In other words, my signature is not really a signature of contract, it's a signature of convenience that allows me to get a piece of paper to put in my pocket for identification purposes, that allows me to sign my checks and do whatever I got to do. But it doesn't in any way make any admissions or confessions or require me to participate in any of your rule book schemes under your Admiralty and Maritime Tontine scheme. Now, to tell you how crazy it was, I just got asked by an attorney how he would defend a program where a gentleman that he was defending was accused of hijacking a car, and that they were claiming that because the car is made all over the world and all over the United States, that the parts, even though they're assembled at one point, they are in what is called the interstate jurisdiction, and that because of that, this crime was now a federal crime. Do you understand? This is how far-reaching this thing has gotten. And when this gentleman signed his driver's license, he had no idea that he was entering into this thing and waiving all of his God-given constitutional rights, and that he was no longer a common law citizen, that he was actually under Admiralty and Maritime jurisdiction. Now, when we pull up some of these statutory requirements, it's an interesting thing that you brought up. But what they do is, these regulations are never enacted into law. We'll show you something on that just a little bit later, but they're not enacted into law. They just make a regulation, and because you voluntarily enter into this contract, all of these regulations just come up as enforceable to you, even though you don't know any better. Now, we have a Fair Credit Reporting Act that says if you make any loan or you get involved in any kind of a credit relationship, they got to tell you everything about how much the interest rate is, what the payments are, how long the payments are. I mean, they got to tell you every single thing about the contract. And in theory, all contracts, you're supposed to know all of the facts in regard to the contract. They just make the contract one-sided. And they figure, well, these people are not that well informed. They're not real bright. We'll just get them to sign this on their driver's license, and they'll voluntarily acquiesce into the situation, and then we can throw all of these regulations at them, and they'll never know how we hit them. So it's very important that you understand when you sign something, read it, for sure. If you don't understand everything that's down there, take it to somebody and ask some questions before you sign it. Because once you sign it, it's harder to get out of. But I highly recommend everybody lose their wallet and go down and redo their driver's license and sign the thing UD when you sign it, and put 1-207 without prejudice. Because right then and there you cut off all of this Admiralty and Maritime jurisdiction and you return back to your contract law of what? You're a common law citizen living at the common law. And they can have their contract, but it's not enforceable. Why is it not enforceable? Because you can state that you signed it under duress. Well, how do I know that? Look, I put UD right after my name. U period, D period. What do you think that means? Under development? Under the deck? That means under duress. When I signed this, I was under duress. I didn't voluntarily sign this. I had to sign this, or the cops were going to cuff me about the head. You see, I was under threat, intimidation, coercion. I still believe that I have a right to travel freely unencumbered. Notice you're not driving. You have a right to travel. The customary usage of the right to travel today is you get in a car. You don't go down to 7-Eleven on your bicycle, you get in a car. You want to go down and pick up a carton of milk, you get in your car. Another unique argument along these lines is, well, Judge, I asked this judge, I says, let me ask you a question, Judge. If I get in my car, the Constitution was still in effect in full force before I got in my car, right? Oh, yeah. Now, when I got in my car and I had my gun, it was still in effect, right? But when I closed the door, the Constitution was suspended, and everybody broke out laughing. How could that be? The act of getting in the car and closing the door made the Second Amendment unconstitutional. I said, that's totally ludicrous. How could that possibly be? You see, they have passed these laws, and they've gotten away with it for so long that it's kind of like a bank robber that's robbed 25 banks in a row, and on the 26th is a little miff that you getting excited. Man, I've done this 25 times. What's the big deal? Now you're going to bust me on the 26th time, and you're going to get all upset. See, they've been getting away with it so long, nobody's ever taken them to the task. They feel like, well, I should be able to get away with it on the 26th time. An unconstitutional act, wrongfully done. It doesn't matter how many times in a row you did it, it's still unconstitutional. And the reality is a person that's properly motivated, properly trained, and properly willing to do whatever is necessary and proper to defend the Constitution will almost always prevail on the merits. And that's what we're doing right now, and they're sweating on that right now. But the reality of this is, and you got to understand, the burden is on you. You want your Constitution, then you damn well better grab a hold of it, and you better hold on tight, and you don't let go for nothing. You read your Constitution, you learn your Constitution, you quote your Constitution chapter and verse, frontwards, backwards, upside down. When people come up to you, well, we want you to take a drug test as part of your job. Go fish. I ain't taking no drug test. I'm not required to prove a negative. You're required to prove a positive. If you think I'm doing something negligent, fine. Then you go file papers and you take necessary precautions and what have you, and we'll go to court. I says, but I'm not going to be convicted before the fact, and then I got to provide evidence that I'm not guilty. That's the cart before the horse. That's back asswards. We're not going to do that. Not only that, the Fifth Amendment says I got a right not to be a participant in a compulsory process that's going to make an incriminating situation to me. Now, I'm not nothing to hide, and I'm not even arguing from what I got to hide. I'm arguing from the fact that the right stands, and I'm exercising it. And then I usually ask some simple questions. Well, if they find anything when I get fired, hell yeah. You're going to be penalized. So there are penalties. And if they find anything, would I be criminally prosecuted? Could be. Huh? So why would you want to do some damn stupid thing like that? give him a piss test. This guy comes up to me at the last convention we had, and they want to take a test as to whether or not he's got any drugs in his system. I said, first of all, what's in my system is between me and my doctor, and none of your damn business. I says, I don't take drugs, and I got nothing to hide, but I'm not going to voluntarily enter into anything. What if your guy screws up and now you say I got drugs? Now I can't get a job ever? What, are you kidding me? This some new hobby you just took up? I'm not going to play that game. It is not my burden to prove a negative. It is your burden to prove a positive. If you have a just claim for which relief can be granted, you go file your papers and we'll sit down and talk. But until such time, you go fish. Because I'm not going to play. I'm not required to play, and I'm not going to play. And if you fire me for the exercise of my constitutional right, I'm going to tell you about Miller versus United States, which says, the claim and exercise of a constitutional right shall not be converted into a crime. And you're doing that, and you're punishing me. And if you fire me for it, I will sue your socks off and attach everything you own, bank, business, and home. Now make my day. That's how I feel about it. So you find another turkey to jerk with, because I'm not going to play. Okay? Now, we want to get into some serious things. I want to get into this this argument about traffic cases. This is the most practical way to deal with traffic cases. When you are pulled over, what is happening? Now you got a policeman. He's conducting discovery. Anything you say can and will be held against you. And if you don't think so, just keep rattling. And it'll all get written down on the ticket. I found that out. Told the officer he'd just been waiting to get this ticket so we can fight it and beat it all the way to the Supreme Court. Wrote that word for word right on the ticket. So, when these people are with you, you keep your hatch buttoned. And I mean, I'm guilty, I admit it. Sometimes I rattle on. It's been known to happen. So I'm telling you not to do it. You button your hatch. If you say anything, it's yes, sir, and no, sir. What can I do for you? And they always like to say, going a little fast, weren't you? I say, I neither admit nor deny, and I leave you to your proofs. Oh, a lawyer. Nah, I'm not a lawyer. But I'm smart enough to keep my mouth shut, because I realize anything I say is going to be putting down on your paper. And so you got a charge, you make it, and I'll see you in court. Oh, you want to go to court? Oh, yeah, I always go to court. I fight everything, murder one. It's kind of like a hobby of mine. You know? Well, let's see what we get. And they walk back to the car, and they start writing. Or they usually come back and they say, well, you're going a little fast. Think about slowing down. We're going to let you go with the warning. You got to have a good day. Thank you, officer. You have a good day, too. God bless you and keep you safe. Okay? Courtesy. I can blow their doors off anytime I want. Still, yes, sir, no, sir. Courtesy. Courtesy pays. You treat people the way you like to be treated, and 9 times out of 10, you will benefit. You treat people like a yahoo, and you're going to get treated like a yahoo yourself. So I highly recommend courtesy as an effective way. I had a policeman one time tell me, you ever ate a flashlight the hard way? And I looked at him and I said, quite frankly, officer, most of the officers I have run into are extremely professional. And I treat them with a great deal of courtesy and professionalism because I respect what they're doing and that they risk their life every day. And at no time would I give an officer enough static that he would want to make me eat a flashlight. I mean, I treat them very cordially, and I respect what they're trying to do. I don't agree with everything they're trying to do, because some of the stuff is kind of unlawful. I said, but I will give them the courtesy they have coming. He turned to me and he said, I'm sorry, I got a big mouth. I didn't mean it. You're right. I was out of line. See, you treat people with courtesy, and 9 times out of 10, you can even back down some guy that's talking a lot of manure. But the louder you talk, and the more belligerent you talk, the more louder and the more belligerent he has to talk. It's kind of like Newton's third law of physics. Every action has an opposite and opposing reaction. You talk crap, then he's got to talk crap. So my advice to people is don't do that. It's unmotivated. Who's doing this, you or him? Remember, the best weapon you have is the one right between your ears. So use it. And watch your mouth. Don't be talking a lot of trash to these policemen. They don't need to hear it. They got a bad day. You might have a bad day. Best thing to do is say yes sir, no sir, and if you got an honest bitch, go ahead. If you make my day. Now we've gone past that. You got the ticket. What are you going to do? Well, look on the ticket. See if he signed it. A lot of times they don't sign it. Guess what? If he didn't sign it, there ain't no sworn complaint. How can you defend against a non-sworn complaint? A lot of times the cop doesn't sign the ticket. Look. Open your eyes. God gave you a set of eyes. Look. Yeah, this guy didn't sign it today. It says, under penalty of perjury, I attest and certify that this is a true and fact complaint. Well, what happens if you don't sign that? It ain't a complaint.
Do you have to sign the ticket when the police officer pulls you over in that situation? Don't they make you sign the ticket?
Sometimes they do. If you sign it, put UD 1-207 without prejudice. That's saying that you received the complaint. That's all that's saying. All right?
So it's okay to do that then?
Yeah, but put UD 1-207. It's not an admission of guilt. It just means that you received the complaint. Okay? If you don't sign it, he's going to take you to jail. I realize that it's unconstitutional. Unless you like jail food, I wouldn't do it. I'd sign the thing, UD 1-207 without prejudice. The signature doesn't do anything. Besides, you want a copy of the complaint anyway because you want to file a brief. Now, how are you going to file a brief if you don't know what the complaint is, right? Now, the next thing you know, you have to notify the court within the time period, and it's usually 10 days. One of their dirtiest tricks is you call in and you think you got it noticed, and guess what? They claim you didn't call in. And they go ahead and say you didn't show up. Then they find you guilty, and bingo, you're out of there. So I recommend you call them, tell them that you want a formal hearing, ask the name of the party you are speaking to. And who am I speaking to? So that you've got a name of somebody that works there to verify that you called. Then immediately or sooner, type up a little notice that says, I, state your full name, do hereby request a formal hearing. Put that in the mail, sent certified mail to them, or run down there and walk right in and get them to set up a hearing. Now, you want a formal hearing. Okay, now, 5 days before that hearing, you are required to serve your papers on opposing counsel. If you don't do it in a timely fashion, Michigan General Court Rule will sock it to you and you will not be able to enter your briefs. Now, sometimes you can get away with it the last minute handing it to them and they won't say nothing, but if they want to hammer you, they can use the 5-day court rule. I have used it effectively several times. Now, you look at what it says on the complaint, whatever it says MCLA, whatever you violated, and you go down and you go to the law library, you look up Michigan Miles Laws Act, you look up exactly what they say, and then you enter a defense. I neither admit nor deny, and I leave you to your strictest proofs in a competent court of original jurisdiction. But before we go that, depending on how you want to play, and there's several ways you can go. If you want to be the hardest-nosed that you can be, you walk into court and don't send no paper. And as soon as they call a case, you, as expediently as possible, you move to the forum up there in the front, and you say in a loud and clear voice, "Ready, Your Honor." You state your full name. I'm giving my appearance before the court in propria persona, which means in your own proper person. In this state, it's pursuant to Article 1, Section 13. I've appointed myself my own attorney, and I'm ready to proceed with my administrative and procedural matters. And at this time, Your Honor, may it please the court, I'd motion for dismissal with prejudice, fair state a cause of action for which relief can be granted. And all of a sudden, the cop will go. Especially if you wear a army jacket and you look like you're 3 sheets in the wind. The cop will lean back and go, "Oh crap, we're going to get sued." I didn't know the guy was a lawyer. And then he'll start talking to the prosecutor, and the prosecutor will go, "Turkey, you brought me one of them kind. I'm going to get killed, and you're going to sit here and pay for it, I promise you." And then what happens is, out of your mouth, you tell the judge in the most clearest and expedient language, "Your Honor, may it please the court, is this a court of law or is this a court of equity?" He will immediately sound off with, "There's no equity here," just like he got hit in the knee with a hammer and his leg jumped. And just that fast. It'll happen that fast. Because he thinks there's no lawsuit here, therefore there's no equity. See, the judges don't even understand what happened with this shift from 1963 where they moved these courts together. So you got to find out what hat the judge is wearing. Is he wearing the criminal hat or is he wearing the civil hat? So you have a right to ask. You say, "Judge, this is a court of law or is this a court of equity?" He goes, "There's no equity here." Now we just did this in a beautiful case. This little gal, she couldn't have been 80 pounds soaking wet. And this cop was about 6'2", about 320, big heavy-duty state trooper. She walks in, "Your Honor, I am representing myself as my own counsel. I would like to proceed with my administrative and procedural matters. But before we go, I have a declaratory ruling, sir. Could I ask you a question?" She goes, "Oh, sure, honey, go ahead." He says, "But you understand, only a fool stands as his own attorney." She says, that may be, sir, but I'm the best person that knows the facts of my case, and I think I have a chance. I'd like to try. Is that okay? No problem. You're right. Is this a court of law, or is this a court of equity? The judge immediately, there's no equity here. She said, thank you, sir. She rolled up her hand. In the hand was a ticket that said civil infraction right across the top, and she said, how may we hear this civil infraction, sir? The judge did a Homer Simpson. He goes, "Ooh, so that's where you're going with this, huh?" The whole court broke out laughing. This little gal, I'm telling you, she is this tiny little thing. She's just a sweetheart. The whole court realized the judge did a Homer Simpson. And then the judge realized he did a Homer Simpson, and then he busted out laughing. He goes, oh, honey, you're not going to pull that here today, are you? And she got a little flushed. She wasn't sure. This was her first time, and she was a little scared. She looked over at an associate of mine. She said, looked at him, and he gave her the nod. And she turned. She said, yes, I am, sir. And everybody broke out laughing again. The cop goes, well, if they're gonna play around, I'm gonna put 15 over on the ticket, judge. And the judge goes, no. You got what's on the ticket. That's what's on the complaint. You're not changing the complaint after the fact. That's perjury. You want me to put you in the coolie? You know, you can't change the complaint. The complaint is the complaint. You signed it. It's true. Got me? If it was 15 over, you should have wrote 15 over. He said, well, I just don't want to screw around. This is just getting out of hand. I mean, she was guilty. Da. And she goes, Your Honor, we haven't even gotten to that yet, Your Honor. There's no jurisdiction. This is where we're at. We're at no jurisdiction. It says, you're right. He said, are we going to go through with this now? Come on, tell me the truth. She says, yes, I am, sir. I'm going through all the way to the Supreme Court, she said. And the judge goes, okay, now, we're going to have to set a hearing. She says, and I'd like a formal hearing too, sir. He said, okay, and I'd like a trial by jury, sir, because the value in controversy is in excess of $20. Pursuant to the 7th Amendment, I have a right to trial by jury. He says, yeah, okay. We'll send you notice. It's been 3.5 weeks. We got no notice. We call them every day. They don't even want to talk about this case. The only reason they said that was so all of the poor little people in the back of the room didn't get the idea that they could get up there and do the same thing this little gal did. They're not going to call her back because they got no jurisdiction. They're not going to try that case because she's going to blow their doors up. Okay? Now that's one of the most beautiful texts and the fastest. And the last time I did it, it was before a particularly obnoxious judge. And he basically said to me, how many times have you pulled this? And I said, no, Your Honor, I think this is the 12th time. He said, going for lucky 13, eh? He said, this is very clever, he says, but I'm going to give you some advice, young man. Don't ever get caught doing nothing in my town. Got me? I said, sir, I never do anything. I'm trying to be a regular gentleman. He said, well, you better not get caught doing nothing, because I will hammer your tail. And I said, does that mean the case is dismissed, Your Honor? He says, it's dismissed. You're out of here. Now, I'm telling you this works, and it works real good. Now, the next effective step that you can do is you can turn around and ask the judge if he's a licensed attorney to practice law, because none of the judges are licensed. Take my word for it. Michigan Constitution says, under the Adjudicature Act, that they're by law to have a license, that they are required to be licensed by the state of Michigan. The state of Michigan does not license attorneys. The Bar Association licenses them. They give them a P number and a card that says, yeah, you're a member of the Bar Association. But if you call up the Bar Association, they will tell you they don't give nobody a license. The state of Michigan doesn't give them a license. The Bar Association didn't give them a license. So what license could they be talking about? A Mickey Mouse license? Because that's the only one that's left. The state doesn't issue one, the bar doesn't issue one, and the one they got hanging on the wall is not a license from the state of Michigan. And the Constitution of the state of Michigan says all judges will be licensed to practice law before the state. And you ask him, where's the guy's license? He doesn't have one. And, Your Honor, may it please the court, since you don't have a license, I'm asking you to recuse yourself until we can get a judge that has a license. Now, a little lady named Virginia Crofts, she's the one that perfected this argument. She's a genius at it. She's a little spitfire. If you ever watch her in court, you're actually going to see a treat, because she is something else. She's got character. She graduated a full attorney from Wayne State University. And then she refused to join the bar because she didn't want to compromise her rights with their political chicanery. And she is a full-fledged, serious business, legal person. And to hear her work in court is absolutely like listening to Stradivari work the violin. She walks in and blows their doors off. Well, she's on about 3 judges now for this same thing. She blew the first judge out, so then they sent in another judge. They moved her over to the other side of town, over in Berkeley, Michigan, and then she walked in and she blew that judge out of the door. So then they sent her to another judge, and then she turned around and went before the state licensing commission, and now they've handed it up to the judicial people of the state to try and resolve the problem. They're going to end up dropping it. The judge doesn't have a license. Now let's suppose the judge could prove he has a license, which he doesn't. Judge, let me ask you a question. Under your retirement fund, isn't it a fact that you get a certain percentage of the rake-off of all of the tickets that come before your bench? Well, yeah. And isn't out of a $40 that comes across your bench, you get $18.75? Well, yeah. So you have a financial interest in this matter, isn't that correct? Well, yeah. Well, isn't that a violation of Judicial Canon number 7? You're not supposed to have any financial interest in any matter that comes before your court. I'm going to ask you to recuse yourself for bias, Your Honor, may it please the court. And every single judge has got it. Now, does everybody understand how many ways you can hammer them just out of the chute without even getting nasty? The judge don't have a license. The judge has got a personal interest in the case for financial reasons. There is no jurisdiction to hear the matter, and I'll tell you a secret. Once you challenge jurisdiction, the burden falls on the plaintiff to prove jurisdiction. See? And he can't do it. It cannot be done. There isn't any. There is no jurisdiction to hear a traffic ticket in the United States of America. I know, you're sitting back, oh, come on, they've been getting this for years. A traffic ticket is a writ of assistance or a bill of attainder. You look in your Constitution, you'll find out bills of attainder are against the Constitution. And it's stated at least twice that I know of, all right? I'm telling you, you read your Constitution. There is no place for a traffic ticket. You cannot have a writ of assistance that has civil equity arguments that transmit into law penalties. They can't throw you in jail for a debt, because that's a debtor's prison. We have a constitutional argument against that also. So how do they do it? Because they wants to, and because you don't know any better. That's how they do it. Okay?
What if they have a court of, they say it's a court of equity?
All right, that's a good question. I'm glad you're paying attention here. If they say they have a court of equity and there is equity, then you turn to them and say, thank you, Your Honor, I appreciate your time. I would like to know who is the injured party and where the contract is. Can you show me the contract? There is no contract unless you didn't sign your license on UD 1-207 without prejudice. Where is the contract? It's when you sign for that license. So don't sign for that license unless you put UD 1-207 without prejudice, UCC 1-207. Now, they can't produce the contract, and if they could produce the contract, you've exercised your waiver under the contract not to give up your constitutional rights to travel freely unencumbered, right? And let me ask you this. Can you enter into an unconstitutional contract? Not lawfully. The contract is voidable for not lawful performance. It has to be a lawful contract for you to enter into it. All right, now the next thing. Who's the injured party? Who got injured? Show me, Judge. The parking meter out there? Another neat trick that I like to do, especially in speeding tickets, is I like to confront my accuser. I always like to call a black box that accused me of speeding to the stand, and the judge always gets upset. And I tell him, well, Your Honor, I said, I've been asking this policeman here for 3 hours how the black box that he's been playing with works, and he can't tell me. And we've been through the whole stationary mobile radar manual from Macomb County Community College Law Enforcement Academy, and I've asked him every question, and I don't know how he passed his second-class radio operator's license, because he doesn't know how the damn thing works, period. He doesn't even know how to set up the test to properly test the thing in all environments. I said, on top of that, I said, he is not the witness. He is nothing but a hearsay witness, and his testimony is inadmissible in any court in the land, because you can't have hearsay. He says, what the hell are you talking about? I said, he did not actually accuse me. That black box with flashing lights on it and little beepers accused me. I said, now if I had a black box in here with little lights on it and making noises and accusing and saying, he didn't speed, he didn't speed, he didn't speed, we know how far that'd go, right through that window, Judge. You'd throw it right out through that window. But you let this guy bring his idiot box in with flashing lights and beepers on it, and his thing is exactly by the book and admissible in court. He can't tell me how the thing works. We've been trying for 3.5 hours to test him to see if he knows how it works. He couldn't pass that test to save his life, and the bottom line is, I still don't think the damn thing works, and personally, I want to call it to the stand and confront my accuser. Under Article 1, Section 13, Paragraph 5, I got a right to confront my accuser, and I'd like to confront my accuser, and I'm serving a subpoena. A subpoena deuces take 'em, which means bring your books and records, too. He goes, that's pretty clever. I says, not only that, Your Honor, he's arguing apples and oranges. See, I got a speedometer in my car, and it might be plus or minus 12 miles an hour on a factory-made one. A handmade one is plus or minus 6 miles an hour. I said, and mine's got a little needle on it, and it works off a little cable that goes in the transmission, it runs off a little gear. I says, it doesn't have 4 decimal places, and it doesn't do space logic and all this other stuff and shoot out a mile ahead and tell me how fast the telephone poles are flying by. I said, he's got this handy-dandy gadget in his car that's measuring speed one way, and I got this one that's measuring speed my way. So how could I be guilty to the extent that his is talking about, because I don't have one of them in my car? Do you see the apples and the oranges here, Judge? It's not really a fair test, is it? He goes, that's a pretty good argument you got there. He says, I'll tell you what we're going to do. You've cost my court enough for the day. I'm going to dismiss the case. What do you think of that? I said, fine by me, Your Honor. But before we do, I have one more bitch, Your Honor. He says, bitch, what's that? I said, you see that police officer there? I have a great deal of respect for that police officer. And I don't like to see that police officer get injured in any capacity. I personally feel that police officer sitting in that vehicle all day, for 8 hours a day, getting bombarded by high-energy microwave energy, is an insult to that police officer's life, to his family. I personally feel for that police officer. I wonder why these guys are so irritable and why they don't want to eat no food and they don't want to jump the old lady when they go home. And I says, I understand why. It's because they're being bombarded by this high-energy microwave. And I said, some of them are getting cancer. I says, I think that this is an atrocity. And I said, I don't think that that officer should be required to sit in that car all day and be bombarded by that high-energy microwave energy, which could cause him to get testicular cancer and all kind of other problems with his life. And just so that the city can make bucks off of these tickets. I says, this is an atrocity. He says, you don't worry about that policeman, that's my job. I worry about that policeman. I said, sir, I worry about him. He works for me. I worry about him. I says, now I've personally run tests on this thing where we took a microwave leak detector right from Radio Shack, which you use to detect the microwave leaks on your radar range at home. And I said, we went over by the radar car, he flipped the switch on, and that thing went in the red. So I know them guys are being bombarded by high-energy microwave energy, and I know that if I had a microwave energy oven at home that was leaking that bad, it'd go in the trash. You understand? Because of the dangerous, hazardous energy that is being given off by the thing. I says, now you ask my police officer here, my friend in the community that's going to protect me, to put a risk of cancer or something like that on his body. I says, I think that's absolutely un-American, and I'm protesting. He said, well, I'll take it under consideration. I said, and I thank you for your concern for our police officer. I said, that's all right, Your Honor. I was trying to be a good citizen. So we walked out of the courtroom, that cop came alongside of me, and he says, I ain't never turning that damn thing on again. And what do you bet that didn't go everywhere? Now that's psychological warfare, folks. That's how it works. And I was right, and I was honestly trying to help him. But he told me he ain't never turning that damn thing on again. Now this happened about 1985. Now they've been publishing in the news just in the last year. You're hearing about all these cops that are coming up with cancer from all kind of various things. Well, this is why, folks, because they're being bombarded by these high-energy radar guns. If I was a policeman, I wouldn't turn that thing on for nothing. I'd cut the wire in the thing. I'm not turning it on. What do you think of that? I'll write a ticket, I'll look in the speedometer, and I'll see how fast the guy is going. If he's going fast, I'll give him a ticket. But I'm not turning that thing on, just so I can have my hair fall out and get a chemotherapy treatment. I don't need that kind of stuff, you understand? I told the judge, I says, you got any kind of idea what kind of power is coming off the end of the antenna on that gun? I said, for every inch that it goes past the windshield, the power curve is squaring itself. Now it's reaching out 1/4 of a mile. You got any kind of idea how much power is coming off the end of that antenna? I said, that poor guy is being bombarded with high-energy microwave energy. I don't think it's right. So anyway, it got dismissed, and psychological warfare worked, and most of the cops in my area don't even have that thing on anymore, because I notice when you go by on my radar detector, it doesn't even go off. So I know that it's effective. Now that's psychological warfare. It's a combination of honesty, and basically I do care about the police officers. I don't want them to be endangered. There are good police officers out there. They have a right to work and have a safe job just like anybody else. Any more than I was upset with them when they dumped Agent Orange on us when we were in Vietnam. I mean, it's illogical, okay? Now the bottom line is a lot of things are going on out here, and you have to be cognizant of what's going on. And you have to be cognizant of your rights. And you have to be willing to take the necessary and appropriate action. And you can have some fun at it. I like an elder gentleman who's one of my mentors, Eustace Mullins. He says, if you're not having fun, you're not doing it right. He says, I'll submit a brief, and then he'll send it back to me, and he'll tell me all the things that are wrong with it, and I'll fix it, and I'll send it right back to him, and I'll add a few more things in there. Then he'll get all mad that I fixed it, and then he'll send me back a thing telling me he doesn't agree with it, and I'll send him back an answer telling me that's too bad, because that's the law. Now, you can have a lot of fun doing this. Another neat thing you can do is go down and sit in courts. I highly recommend ladies or gentlemen that don't have anything to do for an afternoon, retirees especially, get your best gal or your best girlfriend or boyfriend, whatever it is, take two of you. Safety in numbers, take two of you. Dress in your best suit and what have you, tie or best skirt and what have you. Go down and sit in the court and take a legal pad, just two of you, and sit there for the day. In the left, you want to sit in the left rear side, the last pew in the left rear side. And just sit there and do not smile. They'll think you're from the Judicial Tenure Commission. You ought to see what happens. It's great. Everybody gets read their rights. Everybody gets treated like a human creature. It's absolutely uplifting. The judge will stop what he's doing and ask you, we're not here for anything serious today, are we? And I'll say, no, sir, Your Honor, I'm just casually observing. He'll go, no. Why are we here today? Honest, sir, we were just in the area. We heard that you were a real good judge, and we wanted to see you in action. My associate was driving in the area, and we stopped by to see it. He says, that fish smells awful loosely wrapped to me. Now, you tell me why you're here right now. Honest to God, sir, we're just casually observing. Okay, all lawyers in my chambers. Shuts the court down, goes in his chambers. Now, look. They start trying cases in the chambers, and they started trying them in the hallway, and then they were on the other side of the clerk's office at the other end of the hallway. Then they come back, and then the little gal from the prosecutor goes on. She says, what's with the nerd patrol? The judge gave her a look that would kill. Don't you do it today, honey. You keep that mouth zipped. These guys are from the Tenure Commission. We don't want no problems with the state. You button that hatch. I mean, you can have a lot of fun. My associate was just absolutely almost in tears. He could keep his straight face no longer, so I said, all right, we're leaving. We got out. He laughed all the way down to the car, laughed all the way down Rochester Road to the expressway. He said, that's the most fun I had in my life, just sitting there in that day. And everybody was getting off. Guys were getting sentences canceled. Guys were getting out of jail. One guy had $2,500 worth of fines, and they got reduced to $124 and 5 days served. It was $240, and it was going to be 10 days in jail, but the judge turned to me and winked. He says, I can't throw him in jail for a civil infraction. I knew that. So, this is the last offer I'm going to give you, young man. It's going to be $124 and 5 days served. Does that sound good to you? The lawyer turns to me and says, you better take this. This is the best deal you're ever going to get. So I'm telling you, you can be effective as citizens. You can get on the radio. You can call up. We have here Mark Scott on the radio, and we have several people. Mike Reagan. We have Jesus. There's at least 8 or 10 top people. Joe Maxwell is on there, and there's a Newman fellow. Dave Newman, there's quite a few. You get on these talk shows, when you hear them bring up the right constitutional issues, you pop off, you sound off. Tell them, hey, this is America. Last time I heard we got an American flag on a pole out there. Last time I heard we got a constitution, and by God, we're going to keep it forever. Forever. Anybody got a problem with that? Okay? Now, there's a bunch of other things. We're going to take just a little break here, and we're going to come back, and we're going to finish off with some really hard stuff for the advanced students. So come right back with us. We got some more stuff for you. Just like the old squirrel said. Be right back.